Thank you. We will now restart proceedings, and we will now proceed with the division on amendment number 38, and members should cast their vote now. The vote is now closed. Point of order, Gillian Martin.
Thank you, Presiding Officer. I couldn't connect to the app. I would have voted no.
Thank you, Ms Martin. Your vote will be recorded. Point of order, Sharon Dowie.
I would have voted yes.
Thank you, Ms Dowie, and we would hope to have your camera on next time.
I would have voted yes.
Thank you. The result of the vote on amendment number 38 in the name of Sue Webber is yes 37, no 69. There were no abstentions. The amendment is therefore not agreed. We now turn to Group 2, removal for offending. I call Amendment 1 in the name of Sue Webber, grouped with amendments as shown in the groupings. I point out that if Amendment 32 is agreed to, I cannot call Amendment 59 in the group minor and technical preemption. And I call Sue Webber to move Amendment 1 and to speak to other amendments of the group. Ms Webber.
The sounds all over the place there, Presiding Officer. I wasn't coming in and out. I didn't quite hear everything, so maybe who's ever working the sound can...
maybe, Ms Webber, just resume. I'll just repeat and see if we can get all this on the record. So I'm calling Amendment 1 in the name of Sue Webber, grouped with amendments as shown in the groupings. And I'm taking this opportunity to point out that if Amendment 32 is agreed to, I cannot call Amendment 59 in the group on minor and technical preemption, and therefore I now call Sue Webber to move Amendment 1 and speak to other members of the group. Ms Webber.
Presiding Officer, that was much clearer. Thank you so much. Once again, all the amendments in this group have been lodged by me. And as I laid out in the Stage 2 debate, we should be guided, frankly, by the fact that the public expects far more from MSPs, and we should be held to higher standards than those they represent. Being a member of this Parliament is a privilege, not an entitlement. And I believe that regardless of the severity of the crime, any MSP convicted of an offence should be removed automatically, bypassing the need for a recall petition or by-election. As we saw with the case of Margaret Ferrier, yes, I will give way, Ms Slater.
Lawrence Slater.
The member say that was true, even under the circumstances where the UK government has criminalised peaceful protest. So members of this chamber who are protesting causes that they support, such as nuclear weapons or war, or even Scottish independence, could be criminalised for this sort of peaceful protest and therefore lose their seats.
Sue Webber.
I believe that the law is the law, Ms Slater, and maybe my black and white nature is a little bit uncomfortable for the green benches. Because I believe that regardless of the severity of the crime, any MSP, as I've said, convicted of an offence should be removed automatically.
Would you give on that point?
I will, Mr Kerr.
Does Stephen Sue Webber agree that those who make the law cannot then break the law with impunity? The public expect a certain level of conduct from members of Parliament, both here and in other parliaments, and when we let the public down by not adhering to those standards, we're undermining public confidence in the democratic institutions that our country stands by.
Sue Webber.
Thank you. And, you know, we're in a world right now, we can't escape from it, that trust in politicians is an all-time low. And if you think, with the case of Margaret Ferrier, I think I've taken enough interventions, Mr Stewart. With the case of Margaret Ferrier, the recall process can be very, very lengthy, allowing law-breaking politicians to draw that salary for months, even after being found guilty. And at stage 2, there was concerns that my amendments on remand would fall foul of the European Convention on Human Rights, so I removed reference for that reason. And I think the ones I've got today are still being challenged under the spotlight of the ECHR. But I want to submit my amendments today because the Conservatives are tough on crime. My amendments, presiding officer, would still abolish the criminal conviction grounds for recall. Instead, members would be convicted of a custodial or a community sentence would be removed automatically, and that's what's reflected in my Amendment 31. It modifies the Scotland Act to make provision for the automatic removal of any member convicted of an offence. And other amendments in this group remove reference to the criminal offence ground to reflect this change. Presiding officer, these amendments collectively strengthen the principles that MSPs should be held to the highest possible standards of conduct. Members who break the law should not be afforded the opportunity to keep their job through costly petitions, polls or by-elections. They should be treated like the vast majority of the public who would likely lose their job if they committed a crime and a criminal offence. These amendments provide the Parliament with clear and coherent mechanisms to give effect to that principle, because that is what the public expect from their MSPs and those elected to this chamber. I move the amendments in my name.
Thank you, Ms Webber. I call Alex Cole-Hamilton.
So I've only pressed my button because Sue Webber had signalled she wasn't going to take interventions. We recognise that we're not reinventing the wheel by instituting a power of recall to our constituents. This has existed in the Westminster Parliament for a number of years now. And the consensus that has been built over time around recall at Westminster specifies the amount of time to which people have to be sent to a custodial sentence before recall can be brought in. And as such, I mean, we have to recognise that there are laws in our land that we as parliamentarians may never vote for, and as such may never agree with, and by force of our conscience or circumstances beyond our control find ourselves the wrong side of. I think of the times of peaceful protests and civil disobedience, even when in a less enlightened time in the future, with a more draconian administration, I would hope that there would be members of this Parliament who perhaps rose up against some of the more draconian policies by just having a blanket removal of anyone who breaks the law, irrespective of the grounds by which they came to that decision, on grounds rooted deeply in conscience. I will.
Stephen Kerr.
Really confusing to hear a parliamentarian, someone who makes the law of the land, argue that somehow the law must be partial. I mean, the famous figure of justice is blindfolded, simply because the law, we stand equally before the law. The law in that sense is blind to who we are and why we did what we did. It is a matter for the courts to decide these issues, and once convicted, we have to face up to the consequences of our law breaking. And for senior parliamentarian to argue to the contrary is very baffling to me.
Alex Cole-Hamilton.
Well, it shouldn't be baffling to Mr Kerr because, yes, justice is blind, but so, as another famous politician once said, sometimes, presiding officer, the law is an ass. And sometimes parliamentarians in the future may decide to test that and submit themselves, I will in a second, will submit themselves to the judgment of their peers and to the judgment of their constituents. It is wrong that we should, by amendment as Sue Webber proposes, bring in a blanket removal of those parliamentarians. I'll give way to Patrick Harvey.
Patrick Harvey.
Grateful to the member for giving way. Does he find it odd, as I do, that we're being asked to accept this argument from members of a political party who in recent years have provided 2 Prime Ministers who broke the law while in office?
Alex Cole-Hamilton.
I think Patrick Harvey is receiving some much-deserved applause for what was an excellent intervention, and I can see the faces of our Conservative colleagues growing red with shame.
Mr Cole-Hamilton, could you please resume your seat for a second? There's far too much noise all over the chamber. We need to hear the member who has the floor. Mr Cole-Hamilton.
Thank you, Presiding Officer. Patrick Harvey is absolutely right, and the Conservatives should feel shame at the incongruity between their amendment and the recent actions of their own leadership. Prime Ministers, not just one, but two Prime Ministers who've broken the law. Prime Ministers who, by their own admission...
Members, please, less noise.
I will give way on this point.
Stephen Kerr.
I think it's ridiculous that that point has been made by Patrick Harvey and has been agreed to by the leader of the Liberal Democrats, because, frankly, both of those individuals that we're referring to paid the price for breaking the law. If we're going to talk about leaders of political parties that break the law, I don't think the Liberals have a particularly esteemed history in this respect, and certainly the members of the SNP should think twice about throwing stones
I think
towards
we've got the gist of the
glass
intervention,
house.
Mr Cole-Hamilton.
Stephen Kerr there, evoking the memory of Jeremy Thorpe, bringing the sublime proceedings of this Parliament into the ridiculous realm of Conservative fantasy. My goodness, is that the best they've got, Presiding Officer? Yes, Boris Johnson broke the law. He paid the ultimate price, but only after, in his own words, he was dragged out of number 10 with a blowtorch. My goodness me, is this what we've come to? Let's simmer all this down. Fundamentally, this is not about the pastiche...
members, please.
Fundamentally, this is about a very real proposition that in the future we might find ourselves in less enlightened times, in that opposition parliamentarians may vote against and rail against and stand against the laws of this land, and by extension, sometimes by dint of their own conscience, civilly disobey those. Those members, if it's a small crime, shouldn't be recalled, but if they are recalled, it should be up to the public and the case that they made to the people who send us to Parliament to discern whether it merits them being removed from this chamber. I completely oppose the amendments in the name
I
of...
call Martin Whitfield.
I'm very grateful, Deputy Presiding Officer. And it's really just to take up a point that the member who is moving these motions raised about the potential risk of these amendments falling foul, and whether or not she would support the sponsoring member if, for some reason, and I must say I'm unable, along with Scottish Labour, to support any of the amendments in this group, if these were to pass, whether or not she feels the matter should be referred back to the committee.
And perhaps that could be dealt with by the member in her wind-up. I call the Minister.
Thank you, Presiding Officer. Ms Webber's amendments are, on the whole, a mixture of her Stage 2 amendments that are either not moved or disagreed with. And as Stage 2, the Government remains opposed. As I set out during Stage 2, these amendments would, in the first instance, remove the criminal offence ground as a trigger for recall from the bill, leaving recall to be triggered solely by parliamentary sanction. Then any member who is convicted of an offence for which they receive a community sentence of any type or a sentence of imprisonment of up to 12 months will be disqualified and cease to be a member immediately without any recall process, or indeed without any element of appeal against that conviction and sentence being taken into consideration. And this would give rise, to ECHR considerations that would cause the Scottish Government to have concerns about the competence of the bill. Now, whilst thankfully Ms Webber has dropped her initial idea of disqualifying members who have been remanded in custody but have not faced trial, therefore not convicted of any offence, we're still in the territory of disqualifying members before the outcome of any appeal against the conviction or sentence that would disqualify them. Presiding Officer, that can't be right and may give rise to challenge. This difficulty also gives rise to competency issues with the bill that cannot be overlooked. I think this maybe goes to Martin Whitfield's point. If these amendments were to be agreed, Presiding Officer, the Government might need to request a motion to adjourn these proceedings so we can seek to address those competency concerns. Presiding Officer, I'd also like to note that, as drafted, Ms Webber's amendments leave gaps in the process. These amendments would mean that an MSP receiving a sentence of imprisonment of more than 12 months, but who was not imprisoned as a result, would be subject to neither recall nor removal. These amendments are also deficient as they provide no legal definition of the term community sentence. We may all have a rough understanding of what Sue Webber refers to, but legislation needs more than that, and this term is not defined in Scottish legislation. But let me give a flavour of this. I'll give way to Brian Whittle first.
Brian Whittle.
very grateful to Minister Giveaway. I mean, I have genuine concerns here in that we're measuring here a prison sentence of up to 1 year, where you'll be missing from Parliament for up to 1 year, but a sanction of 10 days by the Parliamentary Committee would also trigger that as well. Do you not think potentially within there's an issue? Because you might be able to appeal against a prison sentence, but you can't appeal against the Parliament. There seems to be a conflict here.
Always the Chair, Minister.
And we'll come to the sanctions process in due course. But let me give Parliament a flavour of what might be captured by community sentences. If we take, for example, for the purposes of Scottish Government statistics on community sentences, these cover community payback orders, restriction of liberty orders and drug treatment and testing orders. Now, are we seriously suggesting that that should be captured by this process? The bill, as amended at stage 2, made a clear distinction in relation to convictions arising from criminal offence. Any sentence of imprisonment that did not result in disqualification under the law currently in place, therefore a sentence of more than 12 months that resulted in imprisonment, would result in recall, where the electorate decide whether or not their MSP should or should not remain a member of this Parliament. There would be no gaps in relation to sentences of imprisonment and community sentences, would not form part of either the recall or removal processes. The issue of community sentences was not raised at the Stage 1 debate. A significant change of direction, which was not raised at Stage 1 and which was not agreed at Stage 2, has now been reintroduced in a revised yet incomplete form in a new amendment at Stage 3. So let me also mention the sanctions process that the recall would be based upon. This is a process which would depend on a regime which is currently under review and therefore yet to be agreed by the Parliament. Whilst the recent Rosemary Agnew report... I'll give way to Kevin Stewart.
Kevin Stewart.
I thank the Minister for giving way. And in terms of that review that has not yet finished, that puts us in a bit of a dilemma today around about this entire bill, because one would have thought that that should have been completed and in place before we are legislating on this particular issue. Does he agree with me?
Minister.
I do agree with Kevin Stewart. Whilst the Agnew report has been published and sent to the Standards Committee, in the 4 weeks that are left in this session, when would parliamentarians have a chance to discuss and debate it, never mind set out and agree what they want the sanctions process in this Parliament to look like and how associated changes should take place, for example, changes to standing orders and the Code of Conduct? As someone who is leaving Parliament, I would not want to leave legislation that isn't underpinned by an independent agreed sanctions process with associated guidance and relevant changes to our standing orders. Our new Parliament need to discuss and agree that process so that they can have confidence in it. And I would suggest that is what a committee... I'm not going to give way now. I've given away quite a lot of apologies. And I would suggest that this is what a committee of the new Parliament ought to do. As I've said throughout this bill, the processes being decided are for Parliament and the members of it. Presiding Officer.
Thank you. I call Graeme Simpson. Mr Simpson.
Thank you. Sue Webber's amendments all broadly relate to where the line should be drawn in terms of when a member commits something sufficiently serious that it warrants automatic removal from Parliament altogether. Now, I gave careful consideration in developing the bill to what the appropriate grounds for the initiation of a recall process would be and what the appropriate grounds for automatic removal should be. And key considerations are, will the electorate be left without a representative for an unreasonable period of time? Will the taxpayer continue to pay for someone who is not undertaking their role as an MSP, for example, if they are imprisoned? And what conduct is required by the Scottish people of MSPs in order to be worthy of the position of MSP? Now, I've sought to mirror in general terms the policy intentions and processes of the Recall of MPs Act 2015 in relation to the grounds for recall. In addition, for the criminal offence ground, I also considered grounds that were not included in the 2015 Act to see if the criminal offence ground could usefully be built upon. Now, in relation to community sentences, I took the view that such a sentence would not necessarily remove greatly from the MSP's ability to undertake their role working for the electorate. And whereas, yes.
Ms Hamilton.
To the member in charge for giving way. Does he agree that recall matters rather than straight removal? Because actually, as we know, this Parliament has passed legislation to create a range of criminal offences, all of which this Parliament has also sanctioned the level of punishment and remedy for those crimes, and that by just simply removing a member without the recall process would add an additional tariff to legislation that already exists.
Graham Simpson.
Yes, it would be absolutely absurd not to involve the electorate. Alex Cole-Hamilton is absolutely right. So if a serving MSP receives a custodial sentence, then they're not able to undertake the role of parliamentarian, quite obviously. A short community sentence might be issued for a very minor offence, and this might not reasonably be considered sufficiently serious to justify going back to the electorate or the associated expense to the taxpayer of that recall process. In relation to prison sentences, appeals processes need to be considered, and again, in this regard, I've sought to mirror the appeal provisions in the UK Act, which allows for all appeal processes to be exhausted before the recall process can commence. Now, Amendment 34, as the Minister said in his letter to Sue Webber, has no provision for appeal and may not be ECHR compliant. This is a serious matter, and Sue Webber should not press this amendment. In addition, if a person I won't, Mr Whittle, if you don't mind, I'm almost done. In addition, if a person has been found guilty of a sufficiently serious offence, then it's likely they will receive a lengthy prison sentence, and certainly over 12 months, meaning they'd be automatically be removed from office at the point of sentencing without waiting for any appeals period to expire. And this automatic removal would remove the need for a recall process to be run at all. I stand by my position as reflected in the bill. Yes, I will.
Member in charge for giving way. I wonder if Mr Simpson would agree with me that it would be absolutely unbelievably stupid to see somebody removed from this place, replaced by someone else, then go through an appeal process which finds them not guilty. Where would that leave the legitimacy of the replacement member in all of this? And what would be the repercussions for this Parliament if somebody had been rejected after a court of appeal had found them not guilty?
Graham Simpson.
That's why we need an appeal process, quite clearly. And this amendment here, Amendment 34, I will give way now.
Brian Whittle.
Again, a very genuine question to Kevin Stewart about the right of appeal. Isn't there a right of appeal if this Parliament decides you take a 10-day sabbatical from here? Is there a right of appeal for that?
Graham Simpson.
I would say to Brian Whittle, there are two different processes here. As there are, I wish he would stop interrupting for us from a sedentary position. He's normally
Mr Simpson, please resume. You see, I certainly try my best to stop interrupting from a sedentary position, but I rely on members to comply with standing orders, which, of course, is to show courtesy and respect to all members at all times. Please continue.
Indeed. The bill before Parliament, Presiding Officer, mirrors essentially what is in the 2015 Act in Westminster, which does allow for a parliamentary sanction. So, no, I'm almost done, Mr Kerr. Having said all that, I'm against all the amendments in this group.
Thank you, Mr Simpson. I now call on Sue Webber to wind up and to press or withdraw Amendment 1. Ms Webber.
Thank you, Presiding Officer. And I was quite content that the Minister did draw information to the fact that it's a custodial sentence or a community sentence that has to be given following that guilty verdict. It's not just someone that's found guilty, Mr Cole-Hamilton, but you did state that the law is often an ass, and it certainly is if you consider some of the legislation that we have passed in this place. I don't think the public believe that it's okay for an MSP that's been found guilty to be in this place representing them. And where Mr Day, yes, I was looking at the screen. Flick number 1.
Minister?
I don't want to reduce this debate to a ridiculous level, but a simple question for Sue Webber, Presiding Officer. If she was nicked for speeding on the way home from Parliament tonight, should she be removed from this place? Because based on what she's telling us today, the answer is yes.
Sue Webber.
I think I would get some points. I wouldn't be getting a community sentence. And I wouldn't be going to
Members.
prison unless I was driving at 100 miles an hour through the Cowgate after 7 a.m, when we know none of us should be driving through the Cowgate. I'm not going to give way to Mr Cole Hamilton. And as we've heard on several occasions, right now there is that 10-day sanction that can be given by Parliament, and there is no appeal process for that. So we're looking for parity in appeals, which is what we keep hearing about time and time again. And, you know, what opportunity has there been to make the bill what it was originally intended for? And that is what it's here for. And in terms of the standards review as well, Minister, I was wondering, in your comments there, you made me think or ponder that the government may be reconsidering their support for the bill. So maybe at some point in the afternoon we can get into that a bit more. But, and I also accept that there isn't that definition of a community sentence, Mr Day, in the Scottish legislation. But we do have a position right now where it does seem that the other members and parties in this chamber seem to be rather soft-touch justice and seem to be allowing MSPs that have been found guilty and sentenced to either a custodial sentence or a community sentence to remain representing the public. And I do not believe the public would accept that. So on that premise, I will press my amendments.
Thank you, Ms Webber. The question is that Amendment 1 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Carol Mochan.
Apologies, I couldn't get logged in. My vote is no.
Thank you, Ms Mochan. Your vote will be recorded. Point of order, Jim Fairley.
I couldn't get my phone to log in. I would have voted no.
Thank you, Mr Fairley. Your vote will be recorded. Thank you. The result of the vote on Amendment number 1 in the name of Sue Webber is yes 23, no 84. There were no abstentions. The amendment is therefore not agreed. I call Amendment 2 in the name of Sue Webber, already debated with Amendment 1. Sue Webber to move or not move?
Moved.
Moved. The question is that Amendment 2 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 2 in the name of Sue Webber is yes 24, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 39 in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 39 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 39 in the name of Sue Webber is yes 40, no 69. There were no abstentions. The amendment is therefore not agreed. I now call amendment 40 in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move? Moved. The question is that amendment 40 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Angela Constance.
I would have voted no, presiding officer. Couldn't connect.
Thank you, Ms Constance. Your vote will be recorded. Thank you. The result of the vote on amendment number 40 in the name of Sue Webber is yes 42, no 69. There were no abstentions. The amendment is therefore not agreed. I call amendment 41 in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move? Moved. The question is that amendment 41 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 41 in the name of Sue Webber is yes 42, no 68. There were no abstentions. The amendment is therefore not agreed. I call amendment 42 in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move?
Moved, presiding officer.
Moved. I therefore call amendment 42A in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 42A be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 42A in the name of Sue Webber is yes 26, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 42B in the name of Sue Webber. Already debated with amendment 38. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 42B be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 42B in the name of Sue Webber is yes 25, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 42C in the name of Sue Webber. Already debate with amendment 38. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 42C be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Craig Hoy.
Thank you, Deputy Presiding Officer. My app is frozen, but I would have voted yes.
Thank you, Mr Hoy. Your vote will be recorded. Thank you. The result of the vote on amendment number 42C in the name of Sue Webber is yes 26, no 84. There were no abstentions. The amendment is therefore not agreed. I call on Sue Webber to press and withdraw amendment 42.
Press, please.
To press. The question is that amendment 42 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. Vote is now closed. Thank you. The result of the vote on amendment number 42 in the name of Sue Webber is yes 41, no 69. There were no abstentions. The amendment is therefore not agreed. I call amendment 3 in the name of Sue Webber. Already debated with amendment 1. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 3 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 3 in the name of Sue Webber is yes 25, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 4 in the name of Sue Webber, ready debated with amendment 1. Sue Webber to move or not move? Moved. Moved. The question is that amendment 4 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 4 in the name of Sue Webber is yes 26, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 43 in the name of Sue Webber, ready to debate with amendment 38. Sue Webber to move or not move?
And not moved.
Not moved. I call amendment 44 in the name of Sue Webber, ready debated with amendment 38. Sue Webber to move or not move?
Not moved.
Not moved. I call amendment 45 in the name of Sue Webber, ready debated with amendment 38. Sue Webber to move or not move?
Not moved.
Not moved. I call amendment 5 in the name of Sue Webber, ready debated with amendment 1. Sue Webber to move or not move?
Moved.
Moved. The question is that amendment 5 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 5 in the name of Sue Webber is yes 26, no 85. There were no abstentions. The amendment is therefore not agreed. I call amendment 46 in the name of Sue Webber, already debated with amendment 38. Sue Webber to move or not move?
And not moved.
Not moved. Therefore, we will now turn to Group 3 on minor and technical. I call amendment 47 in the name of Graham Simpson, grouped with amendments as shown in the groupings. I point out that if amendment 32, already debated in the group on removal for offending, is agreed to, I cannot call amendment 59 by way of preemption. I call on Graham Simpson to move amendment 47 and to speak to other amendments in the group. Mr Simpson.
Thank you. So these are minor and technical amendments. Most of them are from me and some from the Minister. And I'll just go through them in turn. There are a number of amendments here that restructure the bill, including to reflect the removal of Part 2 of the bill at Stage 2. Amendments 47 and 49 reflect that Part 2 of the bill concerning removal was deleted at Stage 2, and the reference to a recall termination notice applies to the Act as a whole, as opposed to one part of it. Section 21 of the bill is concerned with the conferral of subordinate legislation making powers. Amendment 7 places the wording of Section 21(5), which was inserted at Stage 2, in a standalone section after Section 9 of the bill. And this is because this rule of law provision confirms the terms on which a recall process may be questioned and does not confer regulation-making powers. Amendment 30 removes the provision from 21(5), which has been moved in accordance with Amendment 7. Amendment 50 is a stylistic refinement. I bet you never heard of that before. Stylistic refinement to remove the word "but", as it is not required. The effect of this provision remains the same. Amendment 51 ensures that the expressions contained in section 14A apply to the relevant chapters of the bill as it's been restructured at stage 2 and following any required printing amendments. Amendment 54 reflects that in the bill as amended at stage 2, section 31 on commencement mentions this part, that being the final provisions coming into force after royal assent and all other provisions coming into force on such day as the regulations appoint. This amendment brings section 21, which is regulation-making power, before section 29 in the final provisions part, such that section 21 comes into force after royal assent. Similarly, Amendment 59, in respect of the section 21A provision, requires the Scottish Ministers to consult with the Electoral Commission prior to making regulations under section 21. Amendment 57 moves the provision in section 22 on the power to replace references with actual dates to the final provisions. Is that an amendment from Mr Whitfield? Yes, absolutely.
Martin Whitfield.
I'm very grateful to Graham Simpson taking the intervention. Can I take him back to Amendment 26, which is the amendment that's putting the references to the Scottish jurisdiction more accurately? Does he envisage a challenge, then, if the conviction and appeal process is in England, that potentially any consequence may go missed or may well be delayed? I understand the challenge that we cannot instruct the English courts to make the notification, but is he confident that there is enough assurances in the bill where we won't end up with an event that bypasses us?
Graham Simpson.
Can I thank Mr Whitfield for that intervention? It's very important. I have considered this issue and I am confident that the bill is sound, or will be, if we pass these amendments. Amendment 56 reflects that the provision in section 22 applies to the whole Act as opposed to the part it originally applied to prior to amendment at stage 2. This reflects part 2 having been deleted from the bill at stage 2. Similarly, Amendment 58 amends section 23 on the meaning of expressions relevant to the criminal offence ground for the purposes of the Act as a whole and not a particular part. Amendment 59 is another restructuring amendment to move the interpretation provisions in section 23, that's relevant to the criminal offence ground, into the final provisions part of the bill. Similarly, Amendment 63 means the general interpretive provisions in section 24 also are moved to the final provisions part. And this is so that both provisions can come into force after royal assent and not be subject to regulations bringing these provisions into force at a later date. Amendments 60 and 62 reflect the amendment of the bill, which now concerns the recall of MSPs only, following removal of the original Part 2 of the bill on removal of members. The reference to the word "part" removed by both these amendments clarifies that these general interpretive rules under section 24 apply to the Act as a whole, as opposed to originally applying only to Part 1 on recall. Amendment 31, 36 and 37 all amend the short title of the bill to remove reference to removal to reflect that the part of the bill concerning removal of members was deleted at stage 2, and I move Amendment 47.
Thank you, Mr Simpson. I now call on the Minister to speak to Amendment 21 and other amendments of the group. Minister.
Thank you, President Officer. As the first group with amendments from Mr Simpson, let me advise Parliament now that we support all the amendments he's brought forward in stage 3. By supporting Mr Simpson's minor and technical amendments in this group, particularly in relation to the short title and the removal of removal, I am doing so on the basis that I do not support Sue Webber's removal amendments in Group 6, which we will come to. I am pointing this out now because it is a quirk of the voting order that the short title amendments will be voted on before the debate on the amendments to reinstate removal for non-attendance. That's before all of the debate has been had on whether the bill should include removal provisions. Presiding Officer, my own amendments 21, 23, 24 and 26 may well be technical, but they are not minor, even if I do say so myself. They are intended to provide clarity that the courts referred to in sections 18, 19 and 20 of this bill are courts in Scotland. Sections 18, 19 and 20 require a court dealing with a case which may meet the criminal offence ground for recall to notify the presiding officer of the outcome of the case and the status of any appeal made. And I want to come back to the question that Martin Whitfield posed to the member in charge of the bill in a moment. As we're all aware, the power to create an obligation for courts in Scotland is within the competence of the Scottish Parliament, but the power to make law for other parts of the UK or to place duties on courts in other parts of the UK is not. These amendments ensure that there can be no doubt on this point. The criminal offence ground in the bill will continue to apply where a member is sentenced to imprisonment in relation to an offence anywhere in the UK. And of course, publicly available information will be at the disposal of the presiding officer to be the source of information needed to act. However, if this bill were to be implemented, if the Parliament chooses to pass the bill, the Scottish Government could explore with the UK Government the use of a Scotland Act order to extend notification duties to courts elsewhere in the UK and put the bill in brace. I'll take Martin Whitfield.
For the Minister for taking the intervention, and it is right, of course it is the Government amendment on that. Isn't the concern that the conviction in England will still count legally, but actually the notification could be problematic depending on circumstances, and actually potentially would rely on the MSP themselves saying, by the way, I'm appealing this? And I welcome the assurance that an investigation may be had post the bill, depending on what passes for it.
Minister.
Well, I think given the media that we have today, I think it's unlikely that an MSP could be sentenced in that way and it not be picked up on. And I strongly suspect that any appeal process would be recorded as well. But as I said, there is an opportunity to put a belt and braces on that I think the Government would take with the bill to pass. And I would therefore urge members to support the amendments in this group.
Thank you, Minister. And I call on Graham Simpson to wind up.
Nothing to add.
Thank you, Mr Simpson. The question is that Amendment 47 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes, the Parliament is agreed. And Amendment 47 is therefore agreed to. I call Amendment 6 in the name of Sue Webber. Already debated with Amendment 1. Sue Webber to move or not move? Moved. Moved. The question is that Amendment 6 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Katie Clark.
Vote. I would have voted no.
Thank you, Ms Clark. Your vote will be recorded. Thank you. The result of the vote amendment number 6 in the name of Sue Webber is yes 23, no 81. There were no abstentions. The amendment is therefore not agreed. I call Amendment 48 in the name of Sue Webber. Ready debated with Amendment 38. Sue Webber to move or not move? Not moved. Not moved. I call Amendment 49 in the name of Graham Simpson. Already debated with Amendment 47. Graham Simpson to move formally.
Moved.
Thank you. The question is that Amendment 49 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament has agreed, and Amendment 49 is therefore agreed to. I call Amendment 7 in the name of Graeme Simpson, ready to debate with Amendment 47. Graeme Simpson to move formally.
Moved.
Thank you. The question is that Amendment 7 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament has agreed, and Amendment 7 is therefore agreed to. I call Amendment 8 in the name of Sue Webber, ready to debate with Amendment 1. Sue Webber to move or not move? Moved. Moved. The question is that Amendment 8 be agreed to. Are we all agreed? No. The Parliament has not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote amendment number 8 in the name of Sue Webber is yes 26, no 84. There were no abstentions. The amendment is therefore not agreed. I call Amendment 50 in the name of Graeme Simpson, ready to debate with Amendment 47. Graeme Simpson to move formally.
Moved.
Thank you. The question is that Amendment 50 be agreed to. Are we all agreed? Yes. The Parliament is agreed. Amendment 50 is therefore agreed to. I call Amendment 9 in the name of Sue Webber, ready to debate with Amendment 1. Sue Webber to move or not move? Move. Move. The question is that Amendment 9 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 9 in the name of Sue Webber is yes 26, no 83. There were no abstentions. The amendment is therefore not agreed. I call Amendment 51 in the name of Graeme Simpson, already debated with Amendment 47. Graeme Simpson to move formally.
Moved.
Thank you. The question is that Amendment 51 be agreed to. Are we all agreed? Yes. The Parliament is agreed. Amendment 51 is therefore agreed to. We now turn to Group 4, recall poll process for regional members. I call Amendment 10 in the name of Graeme Simpson, grouped with amendments as shown in the groupings, and I call on Graeme Simpson to move Amendment 10 and to speak to other amendments in the group. Mr Simpson.
Thank you very much, Presiding Officer. And if it assists members, I'll probably be speaking for around 5 minutes on this section. So I don't know if that helps you decide what to do. So 81 members. I always try to be helpful, Presiding Officer. 81 members supported the bill at stage 1, but concerns were raised about the regional recall process. I made changes at stage 2 in response, and I'm proposing more amendments today. The original process was 2 stages, a petition and then a poll. The new process just involves a poll held on 1 day in the relevant region. If more than 50% of people voting say the MSP should be recalled, they lose their seat and they're replaced in the usual way. At stage 2, the SPPA committee provided cross-party unanimous support for the new process, supporting all but one of my amendments. The new process is simpler, easier for the electorate to engage with, quicker, cheaper for the taxpayer, and it reflects established electoral processes. And it's based on advice from the Electoral Commission, the Electoral Management Board, and the process set out in the Welsh Government's bill, which is also at stage 3. One amendment was disagreed to on the grounds that there was insufficient detail on the face of the bill, and the Minister was concerned the Government would need to decide on matters during the development of regulation, as opposed to Parliament deciding the detail of primary legislation. The series of amendments in this group set out much more detail on the face of the bill. They don't detail question wordings for the poll to enable the Electoral Commission to conduct user test wordings once the bill is passed, and I think that's entirely right. Amendment 10 requires the returning officer to designate voting places and days and/or times of the day when people can vote. The returning officer sets the poll date. Another option would have been to require the presiding officer to specify the poll date, and I'm aware this is the approach in the Welsh Government's bill and that our presiding officer sets the date for by-elections. However, the regional returning officer is, in my view, preferable. Firstly, returning officers set the date for the constituency recall petition process, so appointing the regional returning officer ensures consistency. Secondly, the poll must take place within at most 7 weeks of the recall initiating notice being issued. On that basis, regional returning officers working alongside constituency returning officers will be best placed to establish the date based on practical considerations such as polling place, venue availability. Now, the Welsh Bill allows for 3 months for this process, but I consider it can take place within 7 weeks, but that in working to shorter timescales, those on the ground with informed experience will be best placed to identify a workable date. A 7-week period provided for in Amendment 11 broadly mirrors the timescales for the recall petition process for constituency MSPs. And as mentioned during the Group 1 debate, I want to ensure MSPs are treated fairly, which includes giving constituency and regional MSPs comparable campaigning time to inform the electorate's decision. Amendment 11 sets out that the returning officer must ensure those entitled to vote in the poll have a reasonable opportunity to do so, including that there are reasonable facilities for in-person voting, including being accessible to disabled people. It also includes the requirement for returning officers to consult constituency returning officers on the poll date. Amendment 12 adds detail on providing notice to the electorate that a recall poll is to take place. The notice of the poll must be issued at least 20 working days before the polling day to ensure adequate notice is given. Amendment 13 requires the returning officer to ensure a person who is entitled to do so is able to vote in person at the designated times and places, and also by post. Amendment 14 allows a regional poll to be rescheduled in the same circumstances as a recall petition for a constituency MSP and subject to the same requirements for consultation with the returning officer, the Electoral Commission and the convener of the Electoral Management Board. This would be, for example, where it's not possible to hold the poll, for example, due to a snap UK general election or a local disaster such as a flooding event. This provision sets out the requirements on the presiding officer, including setting an outer limit of 8 weeks from the original date designated polling day for the new poll. This is modelled on Section 2 of the Scotland Act 1998, which allows the presiding officer to postpone a Scottish general election. Amendment 15 sets out that a person is entitled to vote in a recall poll if, on polling day, they would be entitled to vote at a Scottish Parliament election. It also provides for where alterations are made to the relevant electoral register to determine eligibility to vote in the poll. Amendment 16 is on entitlement to vote in person, by post and by proxy. A person may only vote once and cannot withdraw that vote. A person is permitted to vote more than once only when they are a proxy. Amendment 17 is a minor tweak for consistency on entitlement to vote. Amendment 18 provides clarity in meaning of the key terms entitled to vote and polling day. Amendment 28 provides that regulations made under Section 21 may make provision about the times of day that must or must not be designated for voting in the regional poll. Amendment 29 aligns language in the bill on voting in a recall poll. In summary, many of these provisions will sound very familiar to members as they reflect existing electoral processes. In addition, the provisions in Amendments 10, 11, 12, 13, 15, 16 and 28 mirror sections in the bill on the constituency recall petition process in order to ensure these processes are as similar as possible to treat members fairly and with parity of esteem, and I move Amendment 10.
Thank you, and I call Sue Webber.
Thank you, Presiding Officer. The Minister was clear at stage 2 that the regional recall process would need to be redesigned by the member in charge, and to quite a degree as well, and it is clear that these amendments go some way to achieve that. Although I've already put my thoughts forward on how I would perhaps have wanted a regional recall process to be, it has been changed. And if this process is to go forward, we will support the amendments in this group.
Thank you, and I call the Minister.
Thank you, President Officer. I support all of Mr Simpson's amendments in the group, as they do enhance the clarity of the regional recall process by putting more detail on the face of the bill. This was an area, as we've touched on, the committee clearly asked for at stage 2, and which we as the government agreed with. There was a need for new amendments that reflected consultation and engagement with parliamentarians. The amendments make the roles and responsibilities of those who will be responsible for administering the regional recall process clearer. Where it's appropriate, there is detail on the regional poll process that mirrors the detail for the constituency poll. I welcome the consistency and approach arising from the amendments relating to the power to amend dates relating to the poll, including confirmation that this responsibility rests with the presiding officer. I also welcome the clarity that it will be the regional returning officer setting the date for the poll in consultation with constituency returning officers. Presiding officer, Mr Simpson and I have had several discussions on the details of his recall provisions. These amendments help to address the balance between matters that should rightly be considered by and agreed by Parliament and matters that should be dealt with by Scottish ministers by means of regulations within agreed parameters. I therefore support them.
Thank you, and I call on Graham Simpson to wind up. Press to withdraw Amendment 10.
Well, I move Amendment 10. Nothing further to add.
Thank you. The question is, did Amendment 10 be agreed to? Are we all agreed? Parliament is agreed. I call Amendment 11 in the name of Graham Simpson, already debated with Amendment 10. Graham Simpson to move or not move. The question is that Amendment 11 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 52 in the name of Sue Webber, already debated with Amendment 38. Sue Webber to move or not move.
Move.
The question is that Amendment 52 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Keith Brown.
President Officer, I couldn't connect. I would have voted no.
Thank you, Mr Brown. I'll make sure that is recorded. Point of order, Cocab Stewart.
Thank you, Presiding Officer. I couldn't connect either. I would have voted no.
Thank you, Ms Stewart. I'll make sure that is recorded. And the result of the vote on Amendment 52 in the name of Sue Webber is yes 41, no 67. There were no abstentions. The amendment is therefore not agreed. I call Amendments 12, 13, 14, 15, 16 and 17, all in the name of Graham Simpson, all previously debated, with Amendment 10. I invite Graham Simpson to move Amendments 12 to 17 en bloc.
Moved en bloc.
Okay. Does any member object to a single question being put on Amendments 12 to 17? No member objects. Therefore, the question is that Amendments 12 to 17 be agreed. Are we all agreed? Parliament is agreed. Call Amendment 53 in the name of Sue Webber, already debated with Amendment 38. Sue Webber to move or not move. The question is that Amendment 53 be agreed to. Are we all agreed? No. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 53 in the name of Sue Webber is yes 39, no 67. There were no abstentions. The amendment is therefore not agreed. I call Amendment 18 in the name of Graham Simpson, already debated with Amendment 10. Graham Simpson to move or not move?
Moved.
The question is that Amendment 18 be agreed to. Are we all agreed? Parliament is agreed. Takes us to Group 5, reporting on and observing recall processes. I call Amendment 19 in the name of the Minister. Group with Amendment 20, Minister, to move Amendment 19 and speak to both amendments in the group.
Thank you, President Officer. My amendments 19 and 20 in this group respond to two suggestions made by the Electoral Commission in their briefing note on Stage 2 proceedings. First, the Commission noted that the bill did not at that stage contain provisions imposing a duty on them to publish reports on how well any recall process was run. The Commission has such a duty in relation to all other electoral events in Scotland, including Scottish Parliament, Scottish Local Council elections and UK Parliament recall petitions. They suggested the same should apply to Scottish Parliament recall provisions. Amendment 19 therefore provides for a duty for the Electoral Commission to report in relation to each, hopefully rare, recall event, and also enables the Electoral Commission to report on recall issues at any time at its discretion. Amendment 19 makes clear what can be reported on and what cannot. The Electoral Commission cannot, for example, report on whether the grounds for a recall should be changed. That is a matter for this Parliament, but they can report on matters associated with recalls, such as the process itself, campaign funding and accessibility assistance offered to disabled persons. Second, the Commission noted there would be merit in extending the Electoral Observer Scheme consistent with the approach taken for UK Parliament recall petitions. So Amendment 20 does that for the Scottish Parliament processes. These reporting and observation provisions will improve the transparency and public understanding of the new recall processes in Scotland if they are used. Amendment 20 sets out who can observe recall processes and what elements of recall processes can be observed. Individuals accredited by the Electoral Commission may only observe the final count, not the signing of the petition or voting in the poll under this proposal. The exclusion of the signing of the petition is consistent with UK provisions and protects the secrecy of the petition process, bearing in mind that there is only one option on the signing sheet to recall, so attending a signing place indicates a voter's intention. In the interest of parity of esteem between petitions and polls and simplicity of administrative processes, we have extended the same approach to the regional poll. Only the final count may be observed by accredited observers. Officials representing the Electoral Commission will be able to observe every part of the process, including being present at the signing of polling places, to provide us all with assurance that the process was properly conducted. Presiding Officer, I urge support for Amendments 19 and 20, and I move Amendment 20.
Thank you. I call Graham Simpson.
Presiding Officer, I think the Minister has explained his amendments very well, so just to say I agree with them.
Thank you. Minister, anything to add by way of wind-up? Pressing Amendment 19. Question is that Amendment 19 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 20 in the name of the Minister. Already debated with Amendment 19. Minister, to move formally.
Move, Presiding Officer.
Question is that Amendment 20 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 21 in the name of the Minister. Already debated with Amendment 47. Minister, to move formally.
Move formally, Presiding Officer.
Question is that Amendment 21 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 22 in the name of Sue Webber. Already debated with Amendment 1. Sue Webber, to move or not move?
Move.
Question is that Amendment 22 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 22 in the name of Sue Webber is yes 24, no 84. There were no abstentions. The amendment is therefore not agreed. Call Amendment 23 in the name of the Minister. Already debated with Amendment 47. Minister, to move forward.
Move, President Officer.
The question is that Amendment 23 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 24 in the name of the Minister. Already debated with Amendment 47. Minister, to move formally.
Move, President Officer.
The question is that Amendment 24 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 25 in the name of Sue Webber. Already debated with Amendment 1. Sue Webber, to move. The question is that Amendment 25 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 25 in the name of Sue Webber is yes 23, no 82. There were no abstentions. The amendment is therefore not agreed. Call Amendment 26 in the name of the Minister. Already debated with Amendment 47. Minister, to move on.
Move, President Officer.
Thank you. The question is that Amendment 26 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 27 in the name of Sue Webber. Already debated with Amendment 1. Sue Webber, to move or not move?
Moved.
The question is that Amendment 27 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Jeremy Balfour.
Thank you, Committee. Can I just check whether my vote, if it didn't, I would have voted no?
It wasn't recorded, but I'll make sure it is, Mr Balfour. And the result of the vote on Amendment 27 in the name of Sue Webber is yes 23, no 82. There were no abstentions. The amendment is therefore not agreed. Call Amendments 28, 29, 30 and 54, all in the name of Graham Simpson and all previously debated. I invite Graham Simpson to move Amendments 28 to 30 and 54 en bloc.
Moved en bloc.
Does any member object? A single question being put on Amendments 28 to 30 and 54? There is no objection. Therefore, the question is that Amendments 28 to 30 and 54 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 31 in the name of Graham Simpson. Already debated with Amendment 31 in the name of Graham Simpson. Already debated with Amendment 47. Graham Simpson, to move or not move?
Moved.
The question is that Amendment 31 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on Amendment 31 in the name of Graham Simpson is yes 81, no 26. There were no abstentions. The amendment is therefore agreed. I call Amendments 55, 56, 57 and 58, all in the name of Graham Simpson, all previously debated with Amendment 47. I invite Graham Simpson to move Amendments 55 to 58 en bloc.
Moved en bloc.
Does any member object to a single question being put on 55 to 58? No members object. The question is therefore that Amendments 55 to 58 be agreed. Are we all agreed? Parliament is agreed. I call Amendment 32 in the name of Sue Webber. Already debated with Amendment 1. I remind members that if Amendment 32 is agreed to, I cannot call Amendment 59 due to a preemption. Sue Webber, to move or not move? Moved. The question is that Amendment 32 be agreed to. Are we all agreed? Parliament is not agreed. There will be division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 32 in the name of Sue Webber is yes 23, no 84. There were no abstentions. The amendment is therefore not agreed. I call Amendment 59 in the name of Graham Simpson, already debated with Amendment 47. Graham Simpson to move or not move?
Moved.
The question is that Amendment 59 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 60 in the name of Graham Simpson. I would contest that you'd said it very clearly. I have to say I've been relying more on the front bench to be indicating, but nevertheless, there will be a division. Parliament is not agreed. There will be a division on Amendment 59. And the vote is now closed. I've got a point of order from Monica Lennon. Point of order, Monica Lennon. Point of order, Shona Robertson.
So I would have voted yes.
Thank you, Ms Robertson. I'll make sure that is recorded. Point of order, Marie McNair.
Thanks, Presiding Officer. I would have voted yes.
Thank you, Ms McNair. I'll make sure that is recorded. Point of order, Gillian Mackay.
Thanks, Presiding Officer. I think my vote has been recorded. If it hasn't, I would have voted yes.
Thank you, Ms Mackay. I can confirm that your vote was indeed recorded. Point of order, Monica Lennon.
I think I'm now finally off mute. Apologies for that, Presiding Officer. I couldn't connect and I would have voted yes.
Thank you, Ms Lennon. I will make sure that vote is recorded. The result of the vote on Amendment 59 in the name of Graham Simpson is yes 83, no 21. There were no abstentions. The amendment is therefore agreed. I call Amendment 60 in the name of Graham Simpson, already debated with Amendment 47. Graham Simpson to move formally.
Moved.
The question is that Amendment 60 be agreed to. Are we all agreed? Parliament is agreed. Call Amendment 33 in the name of Sue Webber, already debated with Amendment 1. Sue Webber to move or not move?
Moved.
The question is that Amendment 33 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Ariane Burgess.
Apologies, Presiding Officer. That was for the previous vote.
Okay, thank you, Ms Burgess. And the result of the vote on Amendment 33 in the name of Sue Webber is yes 24, no 83. There were no abstentions. The amendment is therefore not agreed. I call Amendment 61 in the name of Sue Webber, already debated with Amendment 38. Sue Webber to move. The question is that Amendment 61 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division of members who cast their votes now. And the vote's now closed. The result of the vote on Amendment 61 in the name of Sue Webber is yes 36, no 67. There were no abstentions. The amendment is therefore not agreed. Call Amendment 62 in the name of Graham Simpson, already debated with Amendment 47. Graham Simpson to move or not move? Moved. The question is that Amendment 62 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 63 in the name of Graham Simpson, already debated with Amendment 47. Graham Simpson to move or not move? Moved. The question is that Amendment 63 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 34 in the name of Sue Webber, already debated with Amendment 1. Sue Webber to move or not move? Moved. The question is that Amendment 34 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division of members who cast their votes now. And the vote's now closed. The result of the vote on Amendment 34 in the name of Sue Webber is yes 25, no 82. There were no abstentions. The amendment is therefore not agreed. Takes us to Group 6, removal for non-attendance. Call Amendment 64 in the name of Sue Webber. Group with Amendments 65, 66, 67, 67A and 71. Sue Webber to move Amendment 64 and speak to other amendments in the group.
Thank you, Presiding Officer. At Stage 2, the committee voted in favour of removing the non-attendance element from the bill. And I, at Stage 2, did bring a series of amendments that introduced and recognised that the committee is more than just attending physically, and that we have now, whether you like it or not, accepted that hybrid attendance is as valid as physical attendance. But I want to bring again, because I do believe that I think it is right for the full Parliament to debate and vote on that element of non-attendance, as this was originally a key provision of the bill. And there was much made of it in the press that it was removed. In 2021 manifesto, the Scottish Conservatives pledged to introduce Mackay's Law, allowing the public to recall MSPs who have broken the law, grossly undermined trust or failed to contribute to Parliament for more than 6 months. And I remain committed to that element of the bill, but I recognise that there were concerns, as I've said, at stage 1 and 2, that there would be an impact on the privacy of members. I totally agree that attendance provision needs to be balanced out by the need to respect the personal lives of members. But that's the reason why I've proposed Amendments 64, 65 and 66, which set out alternate provisions for reintroducing the removal for non-attendance. Amendment 64 would make the provision for an MSP to be removed automatically if they fail to attend Parliament with a 180-day period, unless they receive a leave of absence from the presiding officer. And there is a prescribed list of reasons the presiding officer can grant that leave of absence. Amendment 65 makes a provision for an MSP to be removed automatically if they fail to attend Parliament with a 180-day period, unless they received a leave of absence from the presiding officer, with the presiding officer having discretion over the leave of absence and can grant it for any reason. Amendment 66 would make the provision for an MSP to be removed automatically if they fail to attend Parliament within a 180-day period, unless they request a leave of absence in line with the process set out in standing orders. And Amendment 67 sets out a process for standing orders mentioned in Amendment 66, that the presiding officer must then refer the decision on whether to grant the leave of absence to a committee which will then vote on the decision. I do think, as a Standards Committee, we wouldn't be too keen, or as a sitting Standards member, for that. That's why I have presented alternatives. The MSP would then be able to appear in front of the committee in order to make those representations, and the committee would have that final decision on whether to grant the leave of absence, although they would not be able to disclose any personal details about the MSP's circumstances for requesting that leave of absence. And that's... yes, I would, Lorna Slater.
Lorna Slater.
Some political parties, notably Sinn Féin, say that they will not take their seats as a point of, for them, a point of ethics and morality. They stand on that, and they decide that they're not. That's a principled stance for them. Is the member saying that that sort of principled stance wouldn't be allowed in the Scottish Parliament? However much I may disagree with a member doing that, shouldn't that be allowed?
Sue Webber.
Thankfully, I don't think we have Sinn Féin on the ballot paper here in Scotland. And I do think, frankly, if you are elected and have the privilege to represent your constituents, that you at least need to turn up for work. 67A would change the wording of Amendment 67 so that the process set out in Amendment 7 is not legally binding but rather advisory. And Amendment 71, which I do believe has got a little bit more support across the Chamber, would reintroduce removal back into the long title to reflect the fact that if amendments pass that if my amendments pass, I will, Mr Greer, if you give me a second, this bill will allow for the immediate removal of MSPs in some circumstances, not just recall. Yes, Mr Greer.
Ross Greer.
I'm grateful for Sue Webber taking intervention. She said that it's a privilege to be elected to this place, and I agree. And she says that in return for that privilege, members should at least turn up for work. I can't help but notice that about a third of the Conservative group haven't turned up to vote in this debate, either in person or online. And that appears to be a consistent pattern of attendance in their group. Surely, if it's a privilege and we should turn up for work, that should start with the group moving these attendance amendments.
Sue Webber.
I think my amendments ask for you to turn up for at least 101 in 180 days, Mr Greer. And there's been instances where members from the government, party of government, have not turned up, which is the very reason we brought this bill in. So, and I will take the intervention from Mr Hoy. I've noticed the pinging round.
Perhaps Mr Greer has spotted that some Conservative MSPs this afternoon have been meeting community councils from across Scotland who are appalled at the industrialisation of our countryside under the so-called Green Revolution led by the Green Revolutionaries over there.
Sue Webber.
Thank you, Mr Hoy. And yes, We do have very challenging and complex diaries to manage as MSPs, and we cannot be in every single proceeding in every single committee. And I think that's the whole point of having parliamentary and party groups. So, Presiding Officer, in closing, are we okay with that? I recognise that non-attendance has clearly garnered some concern about members, but I would raise that such a provision already exists at local government level, and there have been a number of incidences where disgraced members have been able to continue to draw a salary without doing any work for constituents who elected them. So perhaps I might invite members to work with me to find a solution to this that would bring non-attendance back into the bill. Thank you, and I move my amendment.
Thank you. I now call Martin Whitfield.
I'm very grateful, Deputy Presiding Officer. And I rise in relation to Group 6 to oppose the amendments that are seeking to reintroduce non-attendance. There was much discussion through the course of this bill about non-attendance, and one of the challenges that we constantly came up to is, what do you mean by non-attendance? We've heard in the interactions in the debate this afternoon that members may not be here for very legitimate constituency and regional purposes outside. And we've heard assertions made about whether the physicality of attending in the chamber is right or wrong. And that sits at the heart of the challenge with regard to non-attendance. It's often related, and indeed the mover of the motion made reference to it in her closing, about the situation within our councils, where attendance is referred to very specifically at a very specific meeting that can be matched or not matched, whereas the role here within Parliament of attendance at committees, attendance here in the chamber, attendance remotely, or is it voting? And we don't have a settled view on how to assess that. And the challenge that all of these amendments put forward will be to place on the presiding officer an almost unimaginable pressure where people are screaming non-attendance, and maybe the presiding officer is aware of information that they rightly cannot put into the public, I will in a moment, Mr. Ever, cannot put into the public domain, but which is pertinent to the decisions that they make with regard to the approved, the prescribed list of approved reasons. And I'll take the intervention.
Sue Webber.
Martin Whitfield, one of the suggestions I've put forward is something that's akin to the system right now for giving members a proxy vote, which I certainly accept has worked well. I don't think any member has had an issue with that either being presented to them, but that was why I put that amendment specifically in to this panel, Presiding Officer.
Martin Whitfield.
I'm very grateful for the intervention, and it may be that indeed this Parliament going forward finds an ability to coalesce around a non-attendance in the same way as we did coalesce around the requirement for people unable to vote for personal reasons to pass that vote on to someone else. But that was an activity that took the best part of 2.5 years to reach at. And it came about through discussions so that we had an agreement what we meant by it, and an agreement about how far we intended those edges to be. I think, with all respect, we haven't reached that point because we can't even define non-attendance in an agreed way across this, whether it be in the chamber or remotely. Not that this debate is not important, and indeed it is important that the debate continues, but in doing so, it perhaps is best done outside of the scope of this bill until we can reach an agreement on what non-attendance amounts to. I'm grateful.
Thank you. And I call on the Minister.
Thank you, President Officer. The Government made its views known on provisions to remove members of this Parliament. On the grounds of non-attendance at Stage 1 and again at Stage 2, we do not support removal for non-attendance then, and we do not do so now. Mark Griffin's amendments agree at Stage 2 remove the non-attendance provisions from the bill, helping to make it recall only. Mark Griffin set out his concerns about, and I quote, monitoring privacy and having a committee of MSPs making judgments on what does and does not constitute a reasonable explanation for non-attendance, end quote. His concern then, and my concern now, is that the bill would force members to disclose personal circumstances, or perhaps the circumstances of family members for whom they act in a caring capacity. As an alternative to Mr Griffin's amendment, Sue Webber said she was testing the water with her Stage 2 amendments, which she didn't press as it was clear that the committee would not support them. These new amendments revive the issue, but with a range of options on the table, and I'm afraid that none of the options are satisfactory, and all of them give rise to competence concerns like those are raised in relation to the amendments in Group 2, and that would again result in the Government perhaps having to seek a motion to adjourn these proceedings if they are agreed to. Before I move to issues of legality, let me set out what to me is a key point here. None of the three options would actually address the problem of non-attendance. All an MSP need do is set foot in the building for 1 day in the 180, or log on to proceedings for 1 day in 180, in order to avoid being removed as an MSP. However, what these amendments would do is impose a burden on those who had a genuine, legitimate reason for being away from this place for an extended period, and require a monitoring and reporting bureaucracy to be put in place to enable the legislation to work. In the first option, the amendment would put into law a limited list that the presiding officer would use to deem an acceptable reason for absence. As with any list, the reasons noted are not exhaustive. And whilst, of course, I welcome that one of the reasons being suggested is caring for someone near the end of life, someone caring for a person who is seriously ill or going through treatment for serious illness such as cancer, but is expected or hoped to recover, would not be deemed as an acceptable reason for absence. And with respect to the Office of Presiding Officer, for option 2, I have concerns that such significant discretionary power should be placed in the hands of the PO, who will be responsible for determining what reasons are acceptable outside of any framework or guidance. Where's the transparency and fairness in that for both the member and for the presiding officer? Whilst the prospect of having a system of notification and approval set out in standing orders with determinations made by a committee does provide a degree of transparency, I return to the point I made earlier. This would require the construction of a bureaucracy to force those with genuine reasons for absence to justify themselves by virtue of having to share their reasons with a committee that does not take account of privacy or confidentiality for a member of or their loved ones. And finally, let me move to that issue of competence. The two options involving the presiding officer lack any external or independent oversight of the removal process. And the third option for removal involves a committee decision to approve a reason for non-attendance. In none of these options is there a plenary vote on removal. The decision of the presiding officer as committee is the only way to avoid removal. These decisions to refuse to accept a reason are not subject to any form of appeal or review, and they could be said to be arbitrary. That would engage ECHR concerns and give rise to issues of competence. Presiding Officer, this is a bill intended to address misconduct and improve democratic accountability of MSPs. Non-attendance, however frustrating that might be for other MSPs, does not indicate misconduct, nor does presence indicate that someone is taking seriously their responsibilities as an elected member. These amendments would not address misconduct, nor would they improve democratic accountability, but they would give rise to issues of competence. I therefore oppose Amendments 64, 65, 67 and 67A. As I will discuss when we arrive at Group 7, I am supportive of Mr Cole-Hamilton's Amendment 35, which adds a review provision to the bill. As a consequence of Amendment 35, a change will be required to the long title of the bill, and I note that Mr Cole-Hamilton is a supporter of Ms Webber's Amendment 71 that would make the required change. On that basis, that this change will be necessary as a result of Mr Cole-Hamilton's amendment, I would support Ms Webber's Amendment 71. Presiding Officer.
Thank you. I now call Graham Simpson.
Thank you. In this group, Sue Webber is reintroducing the idea that MSPs should be required to attend proceedings in Parliament at least once every 6 months, unless they have good reason not to. And it was this approach that first started me on this journey. This section was removed at stage 2. The committee was unconvinced that it could work fairly, even though every workplace in the land does not allow staff to stay away for as long as they like without good reason. Now, Sue Webber's amendments in this group, save for one, don't quite fulfil the brief. Amendment 64 has a very short list of what presumably Sue Webber thinks are acceptable reasons for taking a leave of absence. My issue with this amendment is that there may be other very valid reasons for someone being unable to be at work. I also share the Minister's concern about a lack of any external or independent oversight of the removal process. So I oppose this one. Yes, of course.
Stephen Kerr.
I'm interested because I know Graham Simpson's journey with this bill started with the levels of discontent he felt and others felt about one particular instance where a member did not turn up for work for years. So now we get to this stage of the bill, stage 3, and that whole primary purpose of the bill is not going to be fulfilled in the legislation, proposed legislation in front of us. I would ask Graham Simpson for his reflections on why it is we started off with the intention to remedy a situation that many of us found unsatisfactory, and now we get to this stage and the bill's not going to do what we set out to achieve. I say we because it was the Scottish Conservatives that were promoting this idea initially.
Graham Simpson.
Well, Stephen Kerr is entirely right. That's the history to the bill. I actually started off with a discussion between myself and the now Baroness Davidson. I've been at pains throughout this process not to name individual members. I haven't done that. I have to say, when I was in the Conservative group, we did do that in relation to one member, and I was uncomfortable with that. And I stopped doing that because I don't think it's about individuals. But there will always be individuals who maybe don't attend, and there have been, and there are, and that's just life. But my view was, and it is, that we need to tackle this issue. The question before us is, are these amendments the way to do it? And I would say to Mr Kerr, I know he probably wasn't following the proceedings at stage 2. I'm not expecting him to. He maybe didn't read the committee's report, but they were very uncomfortable with the proposal. And I just had to take a pragmatic view that, well, if that's the way it is. But I do think the issue needs to be addressed. If not now, then in the next session. If I can reassure Mr Kerr, if he's returned, if I'm returned, then we ought to revisit this. So if I can move on to Amendments 65 and 66, they're essentially alternatives to 64, but my issue with them is that they count remote participation as attending, and this of course is our current way of working, but my original proposal was that MSPs should be making the effort to actually come into Parliament once in a while. Now, I know not everyone agrees with that. Mr Kerr possibly does. But I feel very strongly about that, so I oppose these two on that basis. Now, I can see what Sue Webber is trying to do with 67 and 67A by taking the standing orders route, but I have to say that while I'm strongly of the view that non-attendance issue does need to be tackled, I share the Minister's concerns around competence, and I wouldn't want to pass amendments that are not competent, because that could challenge the whole bill if it passes. And therefore, all amendments in this group should be opposed.
Thank you. Call Sue Webber to wind up. Press to withdraw Amendment 64. Ms Webber.
Thank you, Presiding Officer. I do think the public expect us to attend and participate in Parliament. I accept the challenges in the definition of attendance and perhaps participation and what that means as well. But in light of the short break, I will be pressing my amendments today, Presiding Officer.
Thank you. The question is that Amendment 64 be agreed to. Are we all agreed? Parliament's not agreed. There will be division, and members should cast their votes now. And the vote is now closed. Point of order, Fulton McGregor.
Thank you, Presiding Officer. I had difficulty connecting. I'd have voted no.
Thank you, Mr McGregor. I'll make sure that's recorded. The question is, the result of the vote on Amendment 64 in the name of Sue Webber is yes 25, no 84. There were no abstentions. The amendment is therefore not agreed. I call Amendment 65 in the name of Sue Webber. Already debated with Amendment 64. Sue Webber to move or not move?
Moved, Presiding Officer.
The question is that Amendment 65 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 65 in the name of Sue Webber is yes 24, no 84. There were no abstentions. The amendment is therefore not agreed. Call Amendment 66 in the name of Sue Webber, already debated with Amendment 64. Sue Webber to move or not move?
Moved.
The question is Amendment 66 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote's now closed. The result of the vote on Amendment 66 in the name of Sue Webber is yes 23, no 83. There were no abstentions. The amendment is therefore not agreed. I call Amendment 67 in the name of Sue Webber, already debated with Amendment 64. Sue Webber to move or not move?
Moved.
The question, I call Amendment 67A in the name of Sue Webber, already debated with Amendment 64. Sue Webber to move or not move?
Moved.
The question is that Amendment 67A be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 67A in the name of Sue Webber is yes 25, no 82. There were no abstentions. The amendment is therefore not agreed. Sue Webber to press or withdraw Amendment 67.
Moved, please.
The question is that Amendment 67 be agreed to. Are we all agreed? Parliament's not agreed. Double division members should cast their votes now. And the vote's now closed. And the result of the vote on Amendment 67 in the name of Sue Webber is yes 25, no 85. There were no abstentions. The amendment is therefore not agreed. It takes us to Group 7, Review of Removal Protection of Vulnerable Groups. Call Amendment 35 in the name of Alex Cole-Hamilton in a group of its own. Alex Cole-Hamilton to move and speak to Amendment 35.
Thank you very much, Presiding Officer, and I move Amendment 35 in my name. Presiding Officer, members who were elected to this chamber in the 2016 to 21 session may recall that when we amended the Protection of Vulnerable Groups Act, I tried to bring forward amendments that would have required MSPs or candidates to this Parliament to have undergone the kind of disclosure checks that we ask of anyone in a regulated childcare position or who is regulated in terms of working with vulnerable adults. Let me take head on from the outset any incongruity that may be perceived between the intent of my amendments and the scope and reach of this bill and the aims of therein. We are deliberating in this Act the means by which constituents can legally recall their members of this Parliament if the conduct of those members falls below a threshold from which it is no longer fit or proper for them to serve in this chamber. Presiding Officer, I believe that should a member of this Parliament be barred from working with either children or vulnerable adults, then they do no longer or do not meet the standards that should be required of our democratic representatives that our constituents send to this place. And this in itself should represent a threshold for recall. Presiding Officer, the only means we have of verifying that somebody is not barred from working with either children or vulnerable adults is to subject them to the disclosure regime under the auspices of the Protection of Vulnerable Groups Act. Now, many members may have disclosures through the PVG Act process and for other roles that they hold. But the Act is very clear. It is an offence to require a PVG check of someone who is not deemed to hold a regulated position. And MSPs were excluded from those deemed to hold that regulated position when the Act was first introduced. So there's no voluntary route to give effect to this. We can't simply undertake, as good public representatives, to go through disclosure process ourselves or for the parliamentary corporate body to suggest it as good practice or making it part of the induction of new MSPs, for example. It would require amendment of the existing laws around this ecosystem and maybe even its own Act of Parliament. My amendment seeks to begin that process. Before politics, Presiding Officer, I worked for over 19 years in youth work, in the children's rights sector and in youth policy. And in that context, I was asked to join the Voluntary Sector Issues Unit of the Protection of Vulnerable Groups Implementation Board under the Scottish Government. I was closely involved in the development of the legislation prior to the 2007 Act and its subsequent implementation. Since then, the PVG scheme has provided some level of protection and reassurance over people who hold a regulated position as defined by that Act through their work or volunteering responsibilities and have unsupervised contact with either children or vulnerable adults. As the bill makes it an offence to require a check of someone who does not hold such responsibilities, those professional roles and volunteering activities that required are explicitly listed. While the reasoning for that is clear, it does lead to an inflexibility in the application of the scheme when it comes to those who hold elected office. To my knowledge, Presiding Officer, PVG checks are only required of local councillors who are involved in particular functions around the role of corporate parent, or who have, through the course of their responsibilities, access to looked after children and other education-related activities. But the spirit of the discussion in those early days should have considered, including politicians more broadly. We know from bitter experience, Presiding Officer, that those who would harm children or vulnerable adults will and do seek out positions in our society which confer on them power, influence and opportunity. It is my contention that in our role as MSPs, we have all three. Consider the times we offer work experience to high school students. On more than one occasion, pressure of time has seen me ferry a work experience volunteer from the constituency to Parliament or to a visit in the constituency. I've never regarded that as inappropriate, as I have disclosure checks for other roles that I've held, but even if I did, nobody in Parliament has ever warned me not to. Or the many times in my 10 years as an MSP that a vulnerable adult constituent has asked to see me in private in my surgery without my caseworker. We are naive to think that a predator elected to parliamentary office would not take advantage of or manufacture such circumstances. Presiding Officer, I recognise that the Parliament has not taken evidence on this matter, nor does the scope of the bill lend itself to the not insubstantial level of amendment of attendant acts that such a measure would require. Instead, instructing a review, as my amendment proposes, would signal an intent by this Parliament to get this right and introduce a checking regime in time for the parliamentary session commencing in 2031 that can reassure our constituents that every member of that Parliament is fit and proper in respect of information held by the police when it comes to working with children and vulnerable adults. PVG checks are not foolproof, but they are all we have. Members of the press and the general public are frankly astonished to learn that we're not already subjected to them. But I would contend that the case for our inclusion in the scheme is fast becoming unanswerable. Thank you.
Thank you, Mr Cole-Hamilton. I call in the Minister.
President Officer, I was happy to support Mr Hamilton's amendment in principle at stage 2, but cannot support it as drafted. As I noted at stage 2, the 12 months in his amendment to conduct a thorough review on a complex topic that I think we all agree needs careful consideration was too short a period. Particularly given some of this time would be captured by the election period and the formation of a new government. I'm pleased that we've been able to work with Mr Cole-Hamilton on his amendment and have suggested that 18 months is an adequate time for government to carry out such a review. I think this amendment, as Mr Cole-Hamilton has said, signals intent here, and I therefore support his amendment.
Thank you, Minister. I call on Graham Simpson.
I saw Martin Whitfield. He can intervene on me, but I'm going to be very, very brief, because I really do understand the importance of the issue that Alex Cole-Hamilton has raised. People would think it very odd that we're not subject to PVG checks. So I think a key consideration for me is what requirements there should be of any member at their point of election to the Parliament. And if they're barred for any reason from regulated roles working with vulnerable groups, should such an individual be able to be elected to Parliament at all, you might ask? Now, of course, I'll take the intervention.
Alex Cole-Hamilton.
To the member in charge for taking my intervention. I'm also grateful for Graham Simpson working with me on this issue. Does he agree with me that we need to do more? He's mentioned the induction of new MSPs, and I think that if we can't legislate around requiring a disclosure scheme check of new MSPs, that at the very least this Parliament and this corporate body has a duty of care to the vulnerable adults in our constituencies who seek our help, to the school students who come to us for work experience, and that training around working safely in, where possible, supervised capacity and doors open and the rest of it should be part of the induction of new MSPs to this place.
Graham Simpson.
I do agree with that. I would just say about the amendment from Alex Cole-Hamilton, all it does is commits the government to a review and say, yes, I'll take the amendment.
I'm very grateful for Graham Simpson taking the intervention, and the Minister finished just too quick. And I agree, and I think we've already heard in the interventions that have occurred today that this is a massively important article that needs to be looked at. And I am aware from the member who's moving this that he has tried in the past to do it, and we keep hitting up against the same barriers. And one of the things that may be helpful is an indication that if this were to pass, that perhaps the extent of the review might indeed take the opportunity to be slightly wider than what appears in this amendment, given the nature that we've already heard of coming into the Parliament, if there's already a previous ban. And also, my question to the Minister was going to be in relation to whether or not there is in fact a need to amend the long title, given that this is just for a review and it will require primary legislation to bring any consequences of the review into force. I'm grateful to the...
Graham Simpson.
Yes, Martin Whitfield raises, as he always does, very sensible points. I'll close, Presiding Officer, but I agree with the amendment.
Thank you, Mr Simpson. And I call on Alex Cole-Hamilton to wind up and to press and withdraw Amendment 35.
Thank you very much, Presiding Officer. I mean, we in this Parliament have to govern for people as we find them, not as we would wish them to be. And unfortunately, we have recent cause to know of times in various aspects of public life where predators will seek out that position of power and influence and opportunity and exploit it. We just can't wait for something bad to happen before we have to act because of a public clamour to do so. I can see two interventions coming. I'm happy to take them both. I'll take Stephen Kerr and then Jeremy Balfour.
Stephen Kerr.
I just wanted to make a quick intervention to say that one of the things that we've not mentioned, but I think it's worth putting on in the official report, is the fact that parties have a responsibility in terms of the selection and vetting processes that they apply to their candidates.
And
Yes, I'll just respond to that briefly, if I may, Presiding Officer. Stephen Kerr is absolutely right. I mean, my hope is that in the fullness of time, all aspects of elected office that we have competence over. Obviously, we can't confer this on members of Westminster, but my hope is that at every level of political activity, we recognise that in the white heat of an election campaign, where the candidate is actually the central figure around people who will gravitate and has a magnetic personality sometimes, that they too have that late-night access to volunteers that we would perhaps sometimes rather they didn't. And we can't just assume they're good people and that they're not here for the best of intentions. So I fully agree with Stephen Kerr, and I'm quite happy to take an intervention. I think it was Jeremy Balfour.
Jeremy Balfour.
Thank you, Deputy President. I wonder if I can just develop that slightly of what we've just heard between the two. Is, in an ideal world, would we not do the check before the person is nominated to stand? One that gives a bit more clarity and probably saves problems going forward, but it also lets the electorate know who they are voting for. So would you agree with me that in an ideal world there should be some way that before you are nominated to be a candidate, that you have to have this check done?
Alex Cole-Hamilton.
Thank you. I'm aware that the Conservative Party, as the Liberal Democrat, well, Jeremy Balfour is an independent now, forgive me, but many parties, I think all parties, I hope in this place, have vetting procedures already so that they are fielding to the best of their knowledge people of upstanding probity and who are seeking elected office for the best of intentions. So yes, I actually think that the ultimate natural conclusion of my efforts in this would be to see that regime extended to candidates and vetting processes. I'm happy to take an intervention from Keith Brown. Keith Brown.
Yeah, I think I might be right in saying that Alex Cole-Hamilton, like me, would have had to undergo a PVG check in order to host the Ukrainian family. I certainly did. My concern a little bit is, if this was to be taken further, the only rational point would be at the point of nomination. In the same way as you have to declare that you're not a lord or mentally unfit, you would have to declare that you'd passed a PVG test. My one concern is, I don't know how much, I forget how much it costs now, but we don't want to be putting further obstacles in the place of people trying to stand for an election. So, as with the Ukrainian scheme, where the fee was waived, surely in the interest of democracy, the fee should be waived for those who undergo PVG.
Alex Cole-Hamilton.
I think Keith Brown makes an excellent point in his intervention, and yes, absolutely. I don't think it would be legal for us to create a financial impediment to running for election, other than the deposit scheme we have behind all candidacies. So I absolutely agree. We're not reinventing the wheel here. We had, in the development of the original disclosure regime, a voluntary body which covered the cost of voluntary sector organisations undertaking PVG of a certain size. I don't think there's any reason we couldn't replicate that for those seeking elected office. Yes, I'm loving this violent agreement we're having, so I'm happy to take an intervention from Paul O'Kane.
I'm very grateful to Mr Cole-Hamilton for giving way. What engagement has he had with COSLA on these issues, given that there are many members in the Chamber who, as local authority councillors, would have had to undergo a PVG check? That wouldn't have happened prior to our election or our nomination as candidates for the council, but would have happened when we joined the local authority as a member. So I wonder what engagement he's had with local authorities on that issue.
Alex Cole-Hamilton.
So I'm grateful for Paul O'Kane's intervention there. As this bill doesn't have the scope available to actually bring in this sort of change to the regime that I seek, I haven't taken the time to have the full discussions I would wish to with representative organisations like COSLA and others to give effect to this. But I have spoken to our councillors within my party, and I did reflect in my opening remarks around this group the very nature of the disclosure checks that councillors, particularly those who are part of the corporate parent that have inspection duties around the education authority, that they are subjected to the requirements. I think fundamentally, and I will wind up now, Presiding Officer, we do have access, we do have influence, and we do have opportunity of both the vulnerable people, the vulnerable adults who meet us in our surgeries every week, who might and often do ask for a private word with us without the ear of our caseworker, particularly around intimate issues, particularly around health, for example. And then there's children who often will seek to access this place for work experience or volunteering opportunities. We can't just assume that everybody's okay and that without the one sort of threshold of check we have available to us, which is a check against the information held by Police Scotland in the disclosure regime. And
are you pressing or withdrawing your amendment?
I'm pressing my amendment.
Thank you. The question is that Amendment 35 be agreed to. Are we all agreed? Yes. The Parliament is agreed. Amendment 35 is therefore agreed to. I call Amendment 36 in the name of Graeme Simpson. Ready to base with Amendment 47. Graeme Simpson to move formally.
Moved.
Thank you. The question is that Amendment 36 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 36 in the name of Graeme Simpson is yes, 83. No, 25. There were no abstentions. The amendment is therefore agreed. I call Amendment 68 in the name of Sue Webber. Ready to debate with Amendment 38. Sue Webber to move or not move?
Not moved.
Moved. Not moved, I beg your pardon. Yes. I call Amendment 69 in the name of Sue Webber. Ready to debate with Amendment 38. Sue Webber to move or not move?
Not moved.
Not moved. I call Amendment 37 in the name of Graeme Simpson. Ready to debate with Amendment 47. Graeme Simpson to move formally.
Moved.
Thank you. The question is that Amendment 37 be agreed to. Are we all agreed? Yes. the Parliament is not agreed, there will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 37 in the name of Graham Simpson is yes, 84, no, 26. There are no abstentions. The amendment is therefore agreed. I call Amendment 70 in the name of Sue Webber, ready to debate with Amendment 38. Sue Webber to move or not move?
Not moved.
Not moved. I call Amendment 71 in the name of Sue Webber, ready to debate with Amendment 64. Sue Webber to move or not move?
Moved.
Moved. The question is that Amendment 71 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament is agreed. That ends consideration of amendments. I would advise members that I will suspend for 5 minutes for a short comfort break. We will resume the Stage 3 debate at 17:25.